transformative aspect of non-monetary reparation. And I look forward to answering any questions you might have.
Thank you very much, Dr. Miller, for that thorough testimony. Before we proceed, I want to ensure that we have a roll call. So Parliamentarian Johnson, could you presume with the roll call, please? Thank you so much.
Yes, I will. Thank you. Chair Moore.
Present. Thank you.
Yes. Vice Chair Brown. Member Bradford. Member Grills.
Present.
Member Holder.
Here.
Member Jones Sawyer.
Here.
Member Scott Lewis.
Present.
Member Tamaki.
You're muted, Don.
I see him. Okay. Member Montgomery Staff.
Here.
And again, Member Bradford and Vice Chair Brown. Madam Chair, there are 9 task force members and the number needed for a quorum is 5. The number present is 7. A quorum has been reestablished.
Thank you very much, Parliamentarian Johnson. We're going to sit with the testimony of Dr. Miller, and we're going to return to a discussion on that testimony. We're now going to turn to Dr. Derek Hamilton for his presentation. Dr. Hamilton, you may begin when you're ready.
Good afternoon. Thank you for this invitation to present, and definitely applauds and gratitude for the work that you're doing on this extremely important topic around racial and economic justice. So I will introduce myself. I will present some framing and scope of some work. So I'll begin with, I am Derek Hamilton. I am a university professor. I am the Henry Cohen Professor of Economics and Urban Policy and the founding director of the Institute on Race, Power, and Political Economy at the New School. I consider myself an economist who specializes in understanding group-based inequality as a focal point, not simply as an issue. I would consider myself in the genre of stratification economists, ones that try to understand the ways in which identity has consequences in one's life and the costs and benefits associated with investments in identity and the platforms that society structures that might incentivize or disincentivize some of those investments. I also would consider myself a public intellectual. So in addition to generating scholarship, a goal of mine is to actualize that scholarship in a way to improve the human condition and engage with the public in doing so. The institute that I direct, the Institute on Race, Power, and Political Economy, we're interested in the intersections of race, social stratification, power, and political economy with a purpose of promoting economic justice, economic inclusion, civic engagement, and social equity. We begin with a intellectual foundation. So we are truth seekers, and we try to use the rigor of scholarship along with the methodologies that come about from quantitative and qualitative approaches to better understand relationships and phenomena, but with a purpose to translate that scholarship into actionable or practice. And then finally to public engage with media, with policymakers, with advocacy organizations, ultimately with the purpose of promoting a political economy where people can be self-determined, where people can be empowered and structured in a way to promote inclusion, equity, and engagement. We are committed to values. We challenge ideology, but we're committed to values. And again, those values are inclusion, engagement, and equity well beyond class, empowering people. And we do not pursue understanding inequality from individual deficit perspectives, but rather understanding structures and resources that people need to thrive. So some context. Racism has never only been simply an irrational prejudice, but rather a long leveraged strategic mechanism that unfortunately has been used for exploitation and extrapolation that have benefited some at the expense of others. We recognize that the immoral devaluation of Black people has been ingrained in the American and California political economy, and I'm grateful that this committee is interested in a reckoning for something that's long overdue. At issue for this work is government's complicity in generating and facilitating this extreme racial inequality. We can point to our unjust racial wealth gap as an implicit measure of this racist past that I've been describing, that's rooted in a history in which whites have been privileged by government, political, and economic interventions that have afforded them resources and intergenerational accumulation, which contrasts with a history in which Black people, their personhood, and whatever capital and resources they may have established has been vulnerable to exploitation and extrapolation. And again, the key word is by state complicit confiscation, destruction, terror, fraud, and other acts of violence and malfeasance. As a result, today, Black people have, as a group, very little ownership of land or the means of production, and still remain in fear of violence and literal bondage. This history of disenfranchisement is well documented. We can turn to policies like redlining, highway construction, exclusionary zoning, restrictive covenants, et cetera, which have led to the marginalization of Black Americans and constrained their full economic participation. These racial differences cannot be fully explained by a clustering amongst the less skilled. We know that education matters. We know that education matters, particularly within group. However, ironically, across group, Black workers with a college degree are often the most harmed in a relative sense to similarly qualified white workers. And this difference is amplified in economic downturn, where scarcity becomes enhanced privileged positions. In essence, education has not been and cannot be the magic antidote for these enormous disparities that have resulted from state complicit laws, policies, and economic arrangements. Again, we're not trying to diminish education. There's intrinsic value and a purpose to ensure that everyone, regardless of race, has access to high quality education and curriculum with encouraging teachers to facilitate their education. But it is a myth that education has been the causal link to the inequalities that exist today. The economic returns to education are structurally different across race. We overstate the functional role of education to the detriment of understanding the past and the functional roles that wealth and power that result from that past manifest today. Wealth is arguably the paramount indicator of economic security and one's financial agency. We cognitize wealth as an outcome, but its true essence is functional. Wealthier families with financial advantage buy additional advantages for themselves and their children. Lack of wealth, primarily inherited wealth, prevent many families, particularly Black families, from accessing this advantage, contributing to the ever-increasing distance between those born with and without resources. So to achieve racial and economic justice, we need what you all are doing, an honest and sobering confession of these historical and ongoing sins. That authentic analysis will counter the social, political, and economic culture that has arisen today that caricatures Black and poor people in general as welfare queens, deadbeat dads, and super predators, and undeserving, and instead paved the way for authentic narratives, more accurate framing, where inequality is grounded in what it's grounded in, which is resource deprivation. That acknowledgement alone is empty if not accompanied some form of redress. So let me get into some of the scope. We can propose explore innovative policies and policy frameworks to develop potential ways to remunerate Black Americans with special consideration, as stated in the legislation, to Black American descendants from from persons enslaved in the United States. Especially, we can answer what form of compensation should be awarded through what instrumentalities. Ideas and research topics can include the pros, cons, and implications for potential transfers and various forms of these transfers in the state of California. Examples could include direct cash payments, transfers of land, and other financial instruments, including stocks, bonds, etc. One can look at transfers of institutions. One can think about Marshall Plans. The late economist Robert Brown, who was the founder of the Black Economic Research Center and the founder of the Review of Black Political Economy, a journal, and a founding member of the Caucus of Black Americans, has put forth a lot of these various ideas of forms of payment for reparations, which we can consider and advance upon. He talked about per capita lump sum payments, but a caution is, as was pointed out in the previous from the previous speaker, the concern is less so whether Blacks will misuse that money, but a concern that we could consider is the fact that Black people do not own the means of production in California or the United States, and what a transfer payment can mean with regards to growing inequality when you don't own those means of production. In other words, multiplier effects will be generated, and one needs to consider how those multiplier effects generate or reduce inequality, given one group owns and one group has very little ownership of the means of production. Other forms could literally be transfers of those assets or ownership of those means of production. It can come in the form of land. It can come in the form of even stock ownership. One can even think about reparations being paid out in perpetuity or as an annuity, where the resource from some income generating asset becomes the mechanism by which dividends are paid on an annual basis. There is discourse and built up research around domestic Marshall Plan type programs in which one can think of reparations in the form of built up institutions, schools, and other forms of institutions as well. One would also have to consider the potential moral hazard that in building up these institutions, that the intended recipients might not be the ones that benefit the most, and some unintended recipients might be able to benefit in a disproportionate way from some of those institutions. There has been conversations around territorial grants. In the past, there was conversation around repatriation. I imagine that might not be one of the high priorities here, but potentially transfers of swaths of lands as forms of payment. So I will end with also saying that another component could be, well, how could this be financed? And the pros and cons of various forms of finance within California, as well as the capacities and implications of that finance.
Thank you, Dr. Hamilton, for your presentation. So now we will turn to the task force members for questions for not only Dr. Miller, but also for Dr. Hamilton. And we have about 30 minutes for this, so we do have some time. At this time, would any member of the task force like to be recognized for a comment or a question? Member Holder, you're recognized.
Hi. Thank you to both of the speakers for starting us off on a critically important discussion about the community of eligibility. And we know that is something that the public has a lot of eagerness and urgency and concerns around. So it's important to have this iterative discussion and an ongoing discussion with facilitated leadership from scholars like Dr. Miller and Dr. Hamilton. So I wanted to direct a question comment to Dr. Miller. One of the perceptions that we're hearing in this task force is that you can't have reparations under Proposition 209 unless those reparations are lineage-based, right? That seems to be a common perception. And from what I understand you saying, it actually is quite the opposite, right? Where you're saying that you're actually more in danger of a Prop 209 challenge if your reparations are completely lineage-based as opposed to wrongs-based and specifically tied to iterative wrongs that have occurred sequentially over centuries, right? So I just wanted to follow up with you on this what I see as a misperception that you have to have lineage-based reparations, and the community of eligibility has to be determined by direct descendancy from an actual enslaved person that is documented. Can you comment further on that? And Dr. Hamilton, that's open to you as well.
Sure. And some of it actually ties into some of the remedies that Dr. Hamilton talking about. Descent or lineage is certainly one way of establishing an entitlement, and I don't want to minimize that. But I also, as you point out, think that non-lineage, certainly non-lineage from enslaved persons, is a way of establishing an entitlement to reparations as well. And some of the worries raised in some of the more recent federal cases. So in Chicago, it's the In re African American Slave Descendants litigation. In California, it's a slightly older case called Cato. Is the lineage works both ways, and so it works from the injury down, so from the victim down through the descendants, but it also has to work to establish who was the wrongdoer as well. And some of those wrongdoers can be quite hard to identify. There are some ways of expanding the class of wrongdoer, but in some ways they're similar to ways of expanding the class of beneficiaries. So what you can do is you can say that the state has a significant need to address wrongs that it passively stood by and allowed to have happen. And then the final thing is just remember that Prop 209 is actually relatively limited in many ways. It applies to, by its face, to education, government employment, and government contracting. And to the extent that remedies occur outside those areas, then Proposition 209 doesn't apply. One other thing to remember, and I'm not certainly not the only person to say this, is Prop 209 doesn't apply to race-neutral remedy. And so if the wrong is race neutral, so if the wrong is enslavement, that's race neutral, in part because People are still currently enslaved in the United States through sex trafficking and things like that. You might be able to specify particular time periods if you want to try and more narrowly tailor it to particular groups, because of course enslavement was more prevalent for African Americans before 1865. In the Tulsa experience, we have an act of genocide targeted on a particular community. Acts of genocide, you can define an act of genocide in a race-neutral term and say any act of genocide that happened in the city of Tulsa. There is only one. It was an act of genocide against African Americans. So even where you go around Prop 209 by defining things in race-neutral terms, one of the things to remember about American history, as Professor Hamilton said, was that these acts of violence through white supremacy works through racially targeted acts of violence. And by seeking to remedy, for example, historically specified or geographically specified acts of violence, what you're effectively doing is, for the most part, targeting the sorts of race-based wrongs that we would want to remedy through reparations. I hope that answered your question.
Maybe I'll add a little slight addition and try to make the case that the harms of the past didn't just lead to individual issues, but rather structural context today. It's the result in large part of the harms of the past that still has ramifications on the ways in which groups are caricatured, the ways in which policy is developed, in the context by which transaction continues to occur, including police violence.
Did any other member like to be recognized for a question or comment? Member Tamaki, you're recognized.
Thank you. I want to thank also Dr. Hamilton and Dr. Miller. Thank you so much. So this is more in the sense of thinking out loud as I'm puzzling through this. Dr. Miller, Professor Miller. So I think the premise that you're saying basically is that if the task force focuses on the wrong, the fact that the wrong primarily the underlying reality is that it impacts obviously Black people as a race. But if you focus on this specific wrong, whether that is slavery or policing or destruction of homes by freeways, then that is a way to survive a constitutional challenge. And then to the extent that the remedy falls under contracting, education, or employment, then that may be a way to survive a Prop 209 claim. Is that accurate, or am I mischaracterizing that?
Yes, that's accurate.
So the with respect to Japanese Americans, I mean, the specific wrong was the incarceration of this population, the removal and incarceration of this population. There are many differences. I mean, one of them being, as opposed to Black reparations, is that the reparations award only went to people living at the time. So if a person who was incarcerated in the camp died before the legislation was passed and made effective, their descendants, their family members did not get reparations. And, because we were part of that whole effort, of course, we thought that was a terrible outcome. But that was a reality of the legislation. It did not pass down to descendants. That's neither here nor there with respect to Black reparations. I think right now we're talking about two things. One is an uncompensated wrong, a crime against humanity that has cascading consequences. And then there's this continuum that we've been hearing about from each of the speakers of the, what Dr. Powell, Professor Powell has called the badges of slavery, and whether that be Jim Crow or redlining or redevelopment or any of the other things we've been dealing with. But I guess going back to the point, I'm mainly, as a lawyer, concerned about surviving a court challenge, no matter what it is. And so to get out of the gate. And so what I'm looking for is clarification there, how you feel about that. And we're trying to put this sort of constitutional and not violating 209 overlay to solve an anti-blackness problem, this enormous pathology and ideology of white supremacy, but do it in a way that will survive a judicial challenge. So that I'm most interested in that in your testimony.
So two things. You clearly know the outcomes better than me, but a brief reading of the Civil Rights Act of 1988. My understanding was that some remedies went to spouses and children, but no further than that. But I could well be wrong. But it's certainly possible for the government to contemplate the remedy being handed down, and there are a variety of statutes on the books in California for Holocaust victims, for victims of World War II internment by the Japanese, most particularly, I think, the Bracero program that allow heirs and beneficiaries to recover. Some of those statutes were declared unconstitutional, but on other grounds, because the statutes interfered with the federal government's power to conduct foreign treaties. So basically, the worry was it interfered with federal government dealings with Germany, Japan. But the Bracero program withstood that challenge, and so is constitutional. The second part of your question. So there's been two major challenges to the Civil Rights Act of 1988, the Japanese Internment Act. One from a German claiming that he was interned and he should be eligible for compensation, and one Obadeli by a black person who claimed that the act was racially discriminatory. And both the DC Circuit Court and the DC Federal Court, and they're two different courts for those who aren't lawyers, it's a bit weird, but there you go, found that the racial classification, so the racialized treatment of Japanese Americans during the war was so significantly different from the treatment of Germans, for example, that the racial classification was justified. So it is possible to withstand a constitutional challenge, so long as the court found in this case, you make sufficient findings that, for example, it turned out that a number of Germans at the time challenged the internment, just as a number of Japanese descendants and Japanese people did. But the rationale for interning Germans was radically different and clearly based on valid security issues in ways that the internment of Japanese Americans was not. And so with that sort of finding, you can certainly withstand, I think, given the statements in those cases, but even in Adirond, which, as I'm sure you know, is not the friendliest to civil rights litigation, the ability to pay reparations to victims of the Japanese internment. In terms of Proposition 209, again, it's emphasizing the wrong-based nature. Proposition 209, I think, is best understood as a prohibition on preferences, where preferences are, as it were, a generalized use of a classification to engage in a generalized redistribution of education jobs and contracts. Here, the finding would have to be something along the lines of that there were specific wrongs that were inflicted by different institutions or communities, and that the best way to address those wrongs are through, for example, education, employment, and government contracting. It becomes, I think, easier to do that the closer you get to the present time. So, for example, in Tulsa, with our continuing nuisance argument, where the city of Tulsa has expressly undermined Black businesses and refused to contract, I think we have a good argument there that that's directly discriminatory. And so I think that's the sort of finding that the task force should engage in. And I don't want to go in too long, but one last thought is, as a historical matter, I just think it's really, really important. One of the things that's really striking about the Tulsa Race Massacre is we have lots and lots of pictures of the individuals who engaged, the white perpetrators of that terroristic act. None of them have ever been identified. What you get is, in the words of Monica Bell, a Yale law professor, is an undifferentiated, faceless mob, and so there's plausible deniability that anyone is ever connected with this, and that allows the sort of stereotyping and caricaturing that Dr. Hamilton was referring to in his last comments. And I think the more we're able to identify the wrongs and the specific wrongdoers, the better it is for the health of our community.
Member Groves, you're recognized. I think you're still on mute.
Can you hear me now?
Yes.
Okay, I feel like that commercial. Can you hear me now? Can you hear me now? I truly appreciate what both of you, Professors Miller and Hamilton, have brought to this discussion today. I feel as though we are expanding the perspective on a number of fronts. And so I have a question for Professor Miller and a question for Professor Hamilton. For Professor Miller, am I correct in understanding that the idea would be to identify remedies that are not identified by race but by wrongdoing? And if lineage means closely related to a particular harm or a particular wrong, then there's a good chance it avoids constitutional challenges. And then also that the extent, I'm trying to pull all of this together, that the extent that the groups have been excluded from, those groups that have been excluded from benefits, such as living in certain neighborhoods, accessing certain goods, et cetera, that there's a good chance that the approach could survive a challenge associated, a constitutional challenge, a Prop 209 challenge. So that's my question for you. I'll ask Professor Hamilton, I'll ask it now in case you wanted to think about it, Professor Hamilton. My question for you is, given the structural nature of post-enslavement ongoing harms, and even during enslavement structural factors, am I understanding correctly that you suggest cash payments would have limited efficacy, that they would not go far enough to both address and prevent continued structural harms?
Just So the quick response to your question is yes, that's right. A slightly longer response would be to give this example. So Representative Jackson from Georgia introduced a bill in the House essentially to waive the statute of limitations on lawsuits against the perpetrators of the Tulsa Race Massacre, the city, the state, the county. It's not got anywhere in Congress, but he's done that. The problem would be that under federal law, only the victims, the direct victims, would be able to get those remedies. And so part of what had to be done was to put in a clause in the statute amending federal law to allow descendants to recover on behalf of the original victim. So you can think of that as lineage reparations. But that's not the only way to go about it, as you've pointed out. It does avoid some constitutional problems, so it's definitely a tool in the arsenal, but it's not necessarily the only way to go about ensuring avoiding constitutional scrutiny. Two other ways to do it are to, as it were, identify a race-neutral wrong and to identify a race-neutral remedy. So if the wrong is a race-conscious wrong, you can still have a race-neutral remedy, and that is completely permissible under Prop 209.
And I think you have four broad categories for form of payments. One is cash, one is assets, one is institutions, and then the fourth is some combination thereof. And they all have various pros and cons. And obviously, I'm not going to go through each of them, but because I don't think you want me to. But there's something, as Professor Miller mentioned, something useful about offering somebody unconditional cash beyond the finance, which is without any paternalism. This is owed to you. Do what you want with it. But that said, assets in general often have more financial power than income because they have the added effect of being in perpetuity, that in addition to one period in time, it isn't always depletable. And then something like an institution, it has that longevity as well. But with institutions, I think moral hazards really become a problem in that are there ways in which the institutions don't change or evolve in a way that move away from the original mission or expand to recipients for whom it might not have been necessarily targeted from, or are some people better positioned to take advantage of the institutional development because of some existing power they may have had to begin with. One other thing I want to say about the cash payments, which is in economics, we usually, when we talk about models of trade, we have a concept called immiserating growth, where in an international context, if you take a country that has is primarily not a finisher of final products, but rather has to trade with another country that makes final products, you, in an unintended way, can make them worse off by offering them a transfer payment. So another way to state this is, with any form of stimulus, not only do you benefit the initial recipient of the stimulus, but it has multiplier effects or additive effects. And those that are better positioned with regards to ownership of capital often take a bigger share of that multiplier effect. And, I could say in detail, you give someone $100, if they spend 90 of it, the entity that owned the product that they spent that 92, their income grows by 90. And then if they turn around and spend a portion of it, and the next person that owns that entity that they spent it to is also white, then you will have grown the white income in a way that increases higher than that of the black income. So these are some of the considerations we would have to take into account.
Thank you.
So we have about less than 10 minutes left for this presentation. Are there any members that would like to be recognized at this time to ask any last questions to Dr. Miller and Dr. Hamilton? And again, as a reminder, at our last meeting, the UC Research Office gave a presentation surrounding the economic consultant position and shared information about Derek Hamilton and the proposed scope of work. So he has come to this meeting to share or expound upon a renewed scope of work. And so I'm just prefacing that we will not have the time to ratify or that scope of work at this time. We'll have to do that at the unfinished business period tomorrow, and I'll give you all more details about that. But again, I just wanted to wrap up and see if any members of the task force had any last questions for Dr. Miller or any questions to Dr. Hamilton, particularly around the scope of work or any concerns around that. Okay, so I have, wait, Member Holder, go ahead, you're recognized.
Thank you. So Dr. Hamilton, what are the limitations that you are seeing currently with the scope of work, and how can the scope of work be renewed to ameliorate those complications?
The new proposed scope of work is more narrow and specific. I think the original scope would require probably more time. Well, not probably, certainly more time, greater resources, and those are two of the bigger things. And then, and even perhaps more engagement as to specificity of what exactly it would encompass to be able to define it more coherently.
Okay, so I have, Member Tamaki, you're recognized. Go ahead.
Just a quick point. So we're charged under the legislation with making certain findings, including calculations of reparations, determining eligibility and all of that. So I just want to make sure that with the new scope of work, we'll be able to meet our obligations there. And I don't have the legislation in front of me, but that would be, our North Star. I mean, we have to meet that obligation because that's what we're required to do. And is there anything there that would be problematic? Maybe you don't have the legislation in front of you either, but that's a concern in my mind.
Yeah, and of course, I'm offering a perspective, but this ultimately is the decision of the task force. I think based on even some of the remarks made by Professor Miller, specificity of the harms, I think, narrows that in a more coherent way.
Member Bradford, you're recognized.
Thank you, and I apologize. I had to sign off for a minute, and I just came back at the tail end, and I heard Mr. Miller speaking of Tulsa. I'm just trying to see what nexus you were making to Tulsa, because I'm just curious if the Greenwood situation.
Right, and so just very quickly, one of the ways that we sought to avoid some of the constitutional problems that the task force has been discussing is by focusing with specificity on wrongdoing, so that we could identify specific wrongdoers, the city, the state, the county. In our latest litigation, the Chamber of Commerce, the Tulsa Regional Authority, all of whom have done specific acts, so running a freeway through a black neighborhood to fragment it. And then based on those wrongs, identifying both particularly harmed individuals in the first federal lawsuit, the 125 survivors, and in our public nuisance lawsuit, we can actually go a little bit broader, although it's a slightly different set of remedies, and identify the Greenwood and North Tulsa neighborhoods themselves as being essentially targeted for damage to property, health, and safety. And so the basic idea is that the more narrowly that you can identify the wrongs that are done, the easier it is to argue that the remedy is not about racial classifications, but about repairing specific acts of damage.
Got it. So that being the case, wouldn't Allensworth be a fine example as well that's happened to that African-American town in Tulare County, where it was a thriving town until white farmers cut off the water supply to the town, and then they eliminated the train stop and all but decimated a community that was thriving. And that's a prime example. And again, as the author of the Bruce Beach legislation, I say this is Bruce Beach on steroids, what they did. It wasn't the government directly, but it was those surrounding entities that all but ended that town that sits there today as a ghost town. So I think that would be a great example as well.
So given the way you've described it, I'd need to do a little bit more research, but given the way you described it, I'd say that's the case. I actually think it's also worth looking into not just acts of, I mentioned this briefly, I didn't elaborate on it, not just acts of property destruction, that's what you're describing, but also acts of property exclusion. There's plenty of towns in the state of California that precluded African Americans as part of their policy from accessing resources, and that's a sort of direct wrongdoing that I think the task force can also consider in sort of the mirror image of what you're describing with Allenstown.
Go ahead, Dr. Hamilton.
And just to add a little bit also, from my perspective, there's also direct harm and iterative harm. So perhaps another approach to at least consider is benchmarks that might have resulted from both the direct and iterative harms as targets for redress.
I think Allensworth is a great example here in California that we can use. Again, it's identified as a state historical park, but if anyone has been to Allensworth, at best, it's a ghost town. And I think the state has a debt of obligation to make this facility whole and also educate the rest of California of the importance of this town that was founded by a African-American colonel who served this country.
Yes. So I have two quick questions, one for Miller, one for Hamilton, and then I see Vice Chair Brown, and we'll close out with Vice Chair Brown. Then we'll go to our panel on gentrification and homelessness. So for Dr. Miller, I want to talk about the special consideration language in AB 3121. So the full title of the task force is, AB 3121, California Reparations Task Force to study and develop reparation proposals for African Americans with a special consideration for African American persons who are descendants of persons enslaved in the United States. So my question is, under the wrong space approach, or basically under the conceptualization that you presented today to the task force about connecting specific harms to specific perpetrators, which will then give you a specific remedy in return. Would there, in that conceptualization, in your opinion, or based on your studies, be people within that descendant group, like within the African Americans who are descendant of persons enslaved in the United States, who would be left out or left behind based on that conceptualization? Or would it be up to us as a task force to be really crafty to find these specific perpetrators and harms and make sure that it's tied to everyone, so everyone within that group isn't left behind, if that makes sense?
If I understand you, first of all, there's case law saying that Prop 209 does not prohibit investigation at all, so you can consider whatever you want and investigate. the extent Prop 209 applies, it applies only to the making of awards. In terms of looking at specific groups, I think that my approach would be to demonstrate
If I could clarify, Dr. Miller, if I could clarify, for example, for that special consideration language for African American person descended from chattel slavery in the United States, in order to get remedy under the conceptualization that you've offered, do we have to tie that to a specific example like Allensworth, or?
It makes it a lot easier if you do.
Mm-hmm.
So,
right.
So you can do a number of things. You can try and tie it to enslavement in the United States, and in particular look at a particular time period. So you can look at enslavement in California between whenever in 1865, or the California Constitution of 1879 that then becomes a little less discriminatory towards African Americans, so it continues to discriminate against other people of other races. Or you can, to the extent you pull out further and further, though, the worry is under some of the prior case law, so Cato and In re African American descendants, slave descendants litigation. Courts are going to worry about the nexus that you can establish, not, as it were, between the victim and the descendants, but between the victim and the perpetrators. And to the extent that you can make that link tighter, as tight as possible, I think that's going to be key. I think there's a question then about eligibility, because are you going to say all enslaved people in the United States, all enslaved people in California? That might be a sort of issue that you have to engage with. I hope that was helpful.
Yes, thank you very much. And then my question for Dr. Derek Hamilton. So, and this is just for clarification purposes, and then we'll move to Vice Chair Brown. So in October, when the UC California DOJ Research Office came to present and offered Derek Hamilton as an option for our economic consultant position, it was with the understanding that the economic consultant would do the following, which is in AB 3121 in the bill text. So the economic consultant would, subsection E, in consideration of the task force findings, find any form of compensation to African Americans, with a special consideration for African Americans who are descendants of persons enslaved in the United States is calculated. And then subsection F, what form of compensation should be awarded through what instrumentalities and who should be eligible for such compensation. The economic consultant is supposed to do both of those prongs, E and F. And so based on the conversation we're having today, and Dr. Hamilton, you can clarify and confirm this understanding. You're essentially saying that you can no longer agree to the scope of work of doing E and F. You can agree to do F, but not E, because E would take, in your opinion, you said, more resources and more time. And so you're at this time can only commit to subsection F, which is helping us to figure out what forms of compensation should be awarded, but not the calculations itself. So if you could just clarify that and confirm that as the correct understanding, and then if that is the correct understanding, if you could provide any recommendations as to how we, as a task force, can fulfill subsection E, which is the part of the actual calculations.
So the latter part is nuanced and would probably require a iterative conversation rather than a recommendation as to how you would be able to fulfill E. I would say that It's resources, time, as well as clarity as to why I've scoped out F and not E. And then I'd also say that I don't think we had complete clarity at the time, and when I guess the DOJ made the presentation in October or September as to the fulfillment. I think that I think that those are my answers. I guess with F, I definitely have a greater clarity, and given the time constraint as well as the potential budgets that are available, that's something that I'm more confident and assured that I could deliver.
Thank you for that. And Vice Chair Brown, will close with you. You're recognized.
Madam Chair, members of the task force, I think again, I should underscore that in light of Brother Bradford's comment regarding Allensworth as a community that was specifically destroyed by public policy or responsible agencies, that we should also add to that list the Fillmore in San Francisco, the Harlem of the West, in which the so-called redevelopment agency, which became really black removal, admitted through its own self-study that it did an egregious wrong against African Americans. And the community was dispossessed, economically deprived because of gentrification and the failure to keep the promises for redevelopment. I think that we should be careful to identify, actualize, and give facts to the reality that these communities that were destroyed had a ripple effect in causing psychological, social, and physical harm to African Americans. I think that that's particular, that's exact, and is definite in terms of saying, make amends. Show that you really are sorry for it and you're going to do something about it. You will show some fruits of repentance.
Thank you very much, Vice Chair Brown. Thank you also to Dr. Eric Miller and Dr. Derek Hamilton for your thorough presentations. Again, we'll have to revisit Dr. Derek Hamilton's scope of work discussion tomorrow during the unfinished business portion. Thank you again so much, Dr. Miller and Dr. Hamilton. We really appreciate your presence.
You're welcome, and it's great to meet Dr. Hamilton, even if only virtually.
But one day we'll have to change that. Thank you.
Thank you. Have a great afternoon. So now we're going to turn to our gentrification and homelessness panel. I will now introduce our esteemed speakers. And I would like to also announce that we will no longer be hearing from Pete White today, but hopefully we can hear from him at a later date. So our first speaker is Brandon Green. Brandon Green is the Racial and Economic Justice Program Director for the American Civil Liberties Union of Northern California. In this capacity, Mr. Green provides programmatic vision and leadership for advancing racial and economic justice in the state. He previously managed the Civic Design Lab in Oakland and was an attorney and clinical supervisor at the East Bay Community Law Center, where he helped create and lead the decriminalization of poverty clinic. His recent articles, Too Rich to Be Poor, The Hypocrisy of Indigency Determinations, and Mirror, Mirror, Anti-Blackness and Lawyering as an Identity, were published in the Berkeley Journal of Criminal Law and the Harvard Black Letter Law Journal, respectively. His article, Depraved Necessities, Prison Privatization, Educational Attainment, and the Path to Profit, was published in 2013. by the SRBLSA Law Journal. Then we'll hear from Daryl Owens. Daryl Owens is a housing and transportation activist from Berkeley, California. Owens works at California GIMBY, a nonprofit focused on reforming land use laws as a data and policy analyst. He has been extensively featured in national publications like the New York Times and the Atlantic for leading the movement to remove police from traffic enforcement. His work in building neighborhood support for housing with East Bay for Everyone, a pro-housing nonprofit based out of Oakland, California, has been heralded by the National Low Income Housing Coalition and UC Berkeley's Othering and Belonging Institute. Then we'll hear from Damian Goodman. Damian Goodman is the founder and executive director of the nonprofit Crenshaw Subway Coalition. As a successor organization to the Citizens Campaign to Fix the Expo Rail Line, CSC seeks to empower stakeholder groups in the area of Crenshaw-Leimert Park Hyde Park, my hometown, and highlight the issues of equitable and community-centered planning and development in the pursuit of racial and economic justice for South Los Angeles. As a result of the organization's efforts, over $1.5 billion additional dollars have been invested in the mass transit infrastructure of Southwest Los Angeles, including the Leimert Park Village and Farmdale stations and the Crenshaw LAX light rail line. Last but not least, we have Zarita Jones. Zarita Jones is a native of Los Angeles and a proud matriarch of her family. She is the co-founder of her local LA Tenants Union, where she hosts renters' rights workshops. Zarita is also on the steering committee of End Homeless Now campaign and founded a tenants association of 425 units in her apartment unit to fight back. So now I will turn to Brandon Green. Thank you so much, Brandon Green. You may begin when you're ready. Thank you.
Good afternoon, Reparations Task Force members. My name is Brandon Green. I'm the Racial and Economic Justice Program Director for the American Civil Liberties Union in California. Thank you for having me and allowing me to participate in today's discussion. In my testimony today, I'll first discuss some of the work that the ACLU of Northern California has been engaged around the issue of homelessness alongside our colleagues at the other California affiliates. I will then focus on contextual factors that contribute to Black families' disproportionately high risk of homelessness. Finally, I'll highlight legislative campaign efforts that the ACLU and other coalition colleagues are engaged in to enshrine more protections for unhoused populations. My team at the ACLU of Northern California is currently engaged in litigation and investigative efforts across the region to combat the criminalization of homelessness. As I will note, Black Californians are disproportionately represented in every single one of the jurisdictions that we have been involved in. This is unsurprising. Depending on what estimates you look at, approximately 30 to 50% of all unhoused people in the state of California are Black. The truth is evident in our work and profiled in our recently released report, Outside the Law, the Legal War Against Unhoused People. For example, in Chico, California, where 44% of the Butte County unhoused population resides, Black people are overrepresented by close to a factor of 2. In Santa Cruz, Black people represent 1% of the county's total population, but 8% of its unhoused population. In San Mateo County, where we recently litigated an RV parking ban, Black people make up only 2% of the total population, but are overrepresented in the emergency shelter, transitional housing, and unsheltered populations. In our state capital, Black residents of Sacramento are overrepresented among the unhoused population by almost a factor of 3. 13% of the overall Sacramento population, but 34% of the unhoused population. Finally, in San Francisco, only 5% of the overall population is Black, while approximately 30% of the unhoused population is Black. The Black people overrepresented in the unhoused population is neither incidental nor accidental. According to CalMatters, nearly 50% of Black Californians live in houses that were cost burdened in 2018. Nearly a quarter paid more than 50% of their income towards housing costs. Rent burden being defined as spending more than 30% of income on housing, and severely rent burden as more than 50%. This rent burden has not only pushed Black families closer to houselessness, but has also pushed Black families further into the suburbs away from jobs that require longer commutes. This push out has also contributed to gentrification, something my fellow panelists will likely touch on in more depth. The City of Oakland's Department of Race and Equity put out an Equity Indicators report in 2018. The report found African Americans were 41 times more likely than Asians to be homeless. Additionally, of those housed, almost 1 in 4 African Americans did not own their homes. and the majority of African American census tracts had the highest rates of eviction notices. African American households were also 1.67 times more likely to be rent burdened than white households. Furthermore, the home loan denial rates for African Americans was 2.13 times higher than the rates for whites, and white homeowners were least likely to still have a mortgage or loan on their homes, 69%, while African Americans were the most likely to have a mortgage at 79%. According to Cal Matters, the Black population has plunged by 43% in San Francisco and 40% in Oakland, respectively. The intersecting factors have been of great concern for our colleagues and partners in Oakland who work on education equity issues, particularly around the parallels between school closures, predatory lending, and disappearing Black populations. Recent reporting has highlighted racial discrimination in other aspects of housing, including housing appraisals, wherein researchers found that 12.5% of homes appraised in Black communities were valued at less than the original cost of constructing the home. That figure compares to 7.4% of homes in white neighborhoods and 9.4% of homes in Latino areas. Not only are Black people disproportionately represented among the unhoused populations of California, but they're also overrepresented in the carceral system. These two realities are inextricably linked. A 2018 California Health Policy Strategies brief using data from Orange County, Los Angeles, and San Diego found that there was a 26% increase in the number of unsheltered homeless individuals from 2013 to 2017. Furthermore, reported that of these unhoused populations, 70% had a history of incarceration, 28% had recently been released from jail or prison, 13% had been under community supervision, probation, or parole, 32% reported having mental health issues and being formerly incarcerated, and 15% reported both a serious mental health illness and being formerly incarcerated. The Southern California data syncs up with what we know from the 2019 point in time count in 3 California counties as well: Butte County, San Mateo County, and Santa Clara and Santa Cruz County. The ties between homelessness and the carceral system are important because of the impact the carceral system has as an originating life factor for people. A report from the Coalition on Homelessness in San Francisco found that incarcerated people are between 7 and 11 times more likely to have past experiences of homelessness than the general population. Between 25 to 50% of homeless people nationwide have a history of incarceration. In addition, a report by the Prison Policy Institute titled Nowhere to Go, Homeless Among Formerly Incarcerated People finds that formerly incarcerated people are nearly 10 times more likely to be homeless than the general public. It is also important due to the ways in which jurisdictions develop and implement ordinances that further criminalize unhoused populations as a means of pushing those communities out. This approach has been borne out in the various jurisdictions profiled in a report, who as a means of either controlling or pushing out unhoused populations, enacted ordinances that have a cascading economic consequence and carceral consequences that prevent people from exiting homelessness, ticketing them for the behavior that can either be prevented or avoided, saddling them with debt that they cannot pay, and placing them at risk of arrest via bench warrants that also serve to prevent them from accessing necessary services. These anti-homelessness laws are crafted to avoid judicial scrutiny, but enforce and regulate public spaces like their exclusionary law predecessors, i.e. Jim Crow. They do this by creating scenarios where unhoused individuals are forced to either leave the jurisdiction or break the law, and by empowering police to remove homeless individuals from public spaces. These approaches to homelessness have historical undertones and direct parallels to anti-vagrancy laws and segregationist policies wherein people of color were excluded from public spaces and accommodations because they are said to be dangerous or diseased. Any discussion of reparations must take in consideration the surrounding factors that contribute not only to the lack of wealth accumulation for Black people, but the current ways in which Black people are actively being pushed into homelessness and out of communities in which they have historically resided. Along with our coalition partners with the ACLU of Northern California, are hoping to introduce a piece of legislation that would make housing status a protected category to give unhoused communities one more layer of protection and advocates one more tool to fight against policies that, although framed in a racially neutral way, have a racially discriminatory impact. Thank you.
Thank you so much, Brandon Green, for that thorough testimony. Now we will turn to Daryl Owens. Daryl Owens, you may begin when you are ready. Thank you.
I brought a presentation I sent. Does someone else do the slides, or do I just do the slides?
I believe staff will assist you with the slides.
I'm preparing them right now. One moment, please.
Anyways, I'm Daryl Owens. I'm happy to be here and talk to the task force. I intend to not only talk about my personal experiences with gentrification and what I've seen from a lot of the data work that I've done on the impacts of housing affordability in California, but also propose a couple of solutions I think that the task force should consider.
Thank you. We're looking forward to it.
The slide should be up.
That's not mine. That's Goodmon. I'm Daryl Owens. It should be housing issues facing Black Californians.
Apologize.
No problem. And how long do I have? Like 10 minutes, 10, 15 minutes?
You have 20 minutes.
Okay, great. That's it. Great. Yeah. So let's go to the first slide, please. Or I guess the second slide. So the census data from the recently conducted Census 2020 shows what we already know, which is that there is a large exodus of Black Californians out of the state. They are obviously being priced out from the housing unaffordability. And as we can see here, the big hotspot is Alameda County, which is where Oakland is, and Los Angeles County. Next slide, please. This is another map that I've compiled using census data showing that the decline of Black residents is heavily focused in Oakland and actually much of the historic Black enclaves in the Bay Area, such as Richmond and San Francisco. And you also see a similar pattern happening in Los Angeles around, Compton and Inglewood. Next slide. One of the very important things to understand about gentrification is that we tend to talk about it in the recent 10-year economic boom that California has undergone. But it's been a problem for quite a while now, for many decades actually. And if you look at, for example, the decline of Black residents in the 2000s versus the 2010s for a lot of cities in California, here we see Oakland, LA, San Francisco, the decline of Black residents was actually greater in the previous decade than it was in the 2010s. And this is clearly motivated by also the growing affordability crisis, but primarily the subprime crisis in which Black folks were foreclosed and displaced en masse. And this is something that needs restorative justice and not restorative, but reparations to combat, because it has essentially eliminated a large swath of Black wealth and caused a mass exodus out of the state or to suburban and rural areas far away from their jobs. Next slide, please. So we see that a lot of Black folks are moving. I don't know if I can drop in the chat anywhere, if there's a chat. I don't know if that thing exists, but in case it doesn't, I compiled a map of where Black folks are generally moving to. And they're generally moving to southwestern cities like Phoenix and Houston and Dallas, King County and Seattle. These are the sort of top destinations for Black residents. These are the fastest growing Black cities in Atlanta. Their homes are just much more affordable. They build a lot more than California does. And this is leading to an exodus to more cheaper places. And I believe that, can you move to the next slide? I think it's on this slide, but maybe it's not. It's not really. Okay. The reason why is because what we see, and at least my experience with gentrification, is that a lot of these communities are, renter communities. So I grew up in an area of a lot of Black homeowners and a plethora of Black renters, and a lot of people are leaving California because no, you don't have to move to the next one. Thank you. No, that's fine. A lot of Black folks are leaving because they're trying to build wealth. And home ownership opportunities are locked out for them in the state of California or in areas where they would live. So this is a huge problem that we need to confront, which is how do we stop the stem of Black folks who are seeking home ownership from just going off to other areas? And so these are a list of reasons why I think that we need to solve this problem. Gentrification is causing a lot of evictions, which has led to a massive increase in homelessness. Homelessness, of course, got a huge boost after the foreclosure crisis. That's when we really started seeing the shanty towns and the large tent cities because of the foreclosure crisis. We know that Black schools are heavily underfunded because they're dependent on the value of property, and Prop 13 has done tremendous damage to Black schools. And we have a pretty Jim Crow-like economic system where wealthier suburban commuters come into large Black metros and extract wealth but don't pay taxes into the local system, which in turn leads to disinvestment. We also need to address the largest contributor to Black suffering in the last century, which is redlining. And this is something that, we tend to focus a lot on slavery, and slavery is very important. But the denial of Black people to live in certain neighborhoods, the denial of the GI Bill, the FHA not giving Black folks mortgages, essentially prevented Black people from building wealth like their white peers did. And this in turn has led to a never solved, never ending perpetual wealth disparity between Black folks and non-Black people. Next slide, please. Next, thank you. So what are some issues in particular that Black renters face, right? So as I discussed earlier, Black renters are leaving the state, a lot of them because they're trying to find home ownership and they're trying to build wealth. They don't want to pay their landlord their wages forever. We have an issue with Section 8 users who face endless landlord discrimination. We have an issue, as the previous speaker noted, prior convictions, particularly felony convictions. It makes housing almost impossible to find nowadays for people dealing with felonies. And subsidized housing in the state of California is oftentimes built in formerly redline areas themselves. And these are part of the problem. And Black renters are also severely rent burdened. So a couple of proposals that I have that the committee I think should look into is passing a prohibition. The state legislature should pass a prohibition on income, source of income. And background checks to any severe extent. Ultimately, for a landlord, I think the only thing that should concern them is their ability to pay. Using people's past against them, especially in a predatory criminal justice system, is a great way to keep Black folks in perpetual homelessness. I think that for a lot of urban areas, we want to look into co-housing ideas. And I would like them to also have, in addition to being co-housing systems, maximum planning flexibility. So I mentioned Fillmore in there. There's a really good Fillmore cooperative that is mostly Black, and they're going to use like market rate units and commercial to like generate lots of revenue and build wealth. I think that we should also look at lending practices for potential Black homeowners to buy housing. That frankly, if you have any history or a family that was denied loans in the previous century, and it was by the FHA, it was essentially racialized discrimination that was completely legal at the time. You should have a much lower standard to acquire a loan than other groups of people. It doesn't have to specify race, but FHA redlining will clearly consistently indicate people of African descent. Next slide, please. So issues facing Black homeowners is that, and this is a very prominent problem from where I'm from in Oakland and Berkeley, is that a lot of Black homeowners, as soon as they run into a financial issue, cash out their houses. And because that's the only asset of value they have. So you have a lot of Black folks with low incomes, and all of a sudden they're sitting on $1 million house. Reverse mortgages are a primary way in which a lot of Black folks get displaced in California. And this is a huge problem because this means that they don't have any other sources of income. We also have some Black folks living in, unsafe conditions because they're subdividing their homes illegally without proper standards. And we have an issue too, which is that a lot of Black folks, when they're homeowners and they sell their houses, they don't sell to other Black folks. A lot of other communities just don't do that. They try to make sure that land and property stay within their community, but Black folks, in order to get the highest amount of money they possibly can, are oftentimes forced to sell to people who are not Black. So there's a couple things we need to do here. I think number one, this has come up in Oakland a lot among community groups, and I think this is a really great idea. Recent laws that allow for multifamily housing, that we should not only help and assist Black homeowners in building a second unit, but also basically finance it from a public sector. This will allow a lot of Black homeowners to build wealth without actually having to sell their homes, which is a really great idea. I think that we should push on. I think that we need to absolutely fine and penalize assessors who are undervaluing Black property. If an assessor is found doing that, then they need to be barred or heavily penalized. And those are some of the big two things that I think we could do for Black homeowners in the state. Next slide, please. This just breaks down some, I think, reparations that would be really good. I mentioned earlier about, cooperatives and community groups doing their own housing projects. This is very common in Canada among Native Indigenous nations. I don't know how to pronounce the name, but if you Google that name, Senakwu, I can't pronounce Senak, I believe. This is a really big example of Native nations in Canada building wealth through building housing and through providing housing for their own communities. They do both. It's really smart, and they have complete control over their land as a reparation. I think also if we want to look at public housing, there's currently a public housing bill in the legislature that I helped contribute to with my group East Bay for Everyone, and there's a lot of good ideas from places like Singapore for where the government builds public housing, but unlike public housing here where there's no way to build wealth in it, you just essentially pay rent. In Singapore, you own the public unit under a century-long lease. This can allow for public subsidies to give Black folks a rightful reparation and building up equity paid for by the state. And also we could look to and this isn't necessarily reparations, because we should separate reparations out from how to solve the housing crisis in general, but there are places like Houston, which has reduced homelessness considerably by building a lot of affordable housing and doing a lot of hotel and motel conversions, and also just keeping prices down in general. Not perfect by any stretch of the imagination, but it is, I think, something that California should look towards as well. And that will end my presentation. Thank you very much.
Thank you very much, Daryl Owens, for that enlightening presentation. We will now turn to Damian Goodman from the Crenshaw Subway Coalition. And Damian Goodman, you may begin when you are ready. We can't hear you. I don't know if it's the headphones. I'm not sure. Yeah, we can't hear you, Damian. It says you're off mute, but we can't hear you. So the audio is still not working. Is there a staff member that can assist Damian? We can't hear you. I'm not sure if logging in and out would be helpful. I'm not sure if a staff member can jump in and assist him in the back channels.
Well, we will do our best to try to, Mr. Goodman.
Okay, we'll move on to Zarita Jones, and then we'll return to Damian Goodman. So Zarita Jones from the LA Tenants Union and Crenshaw Subway Coalition, you may begin.
Thank you so much. And can everyone hear me?
Yes.
Oh, wonderful. I just wanted to say thank you very much for the opportunity to be heard today. When trying to examine the problem that we're having with housing and within the current year of 2021, we have to historically actually look back and try to figure out how to correct the wrongs of the past and make it equitable for African Americans and the descendants of freedmen. When
Ms. Rita Jones, I'm not
thinking
sure if
about,
you get, I'm sorry, I don't mean to interrupt you, but I just
yes,
wanted to acknowledge that your camera is off. I'm not sure if that's intentional or not,
oh, how
but if you
about that?
wanted to,
There you go. Is that better?
yes.
Oh,
Yes, that's
wonderful.
better. So could you restart and then we'll go to Damian Goodman. So Zarita,
Sure,
you
sure.
can start your presentation. Thank you.
I just wanted to say when trying to examine the problem that we're having with housing in the current year of 2021, we have to historically look back and try to figure out how to correct the wrongs of the past and make it equitable for current African Americans and the descendants of freedmen. When thinking about the housing crisis and what we have now, specifically after COVID, that has brought to light, it is shown that blighted communities and communities that were disinvested in, um, um, there's three different factors that are very, very troubling, including those factors are the eviction history and the incarceration rate and the overall view of African Americans in housing. The first time I heard an owner and their management team refer and address my mother as you people, it put a very interesting light on the conversation and the meaning in any way, shape, and I'm not trying to sound racist in any shape or form, but we were living in a fourplex and we were the only African American families that were residing there. And we had all Latinx neighbors. Um, my mother was always accused of something that she hadn't done, discarding furniture in the yard or having more than one vehicle crisscross parked in the yard, along a few other things, that she always never had any part. It seemed as though that we were always targeted with notices and threats of eviction and things that we had never done in our lifetime. This brought to light something that I had seen as a pattern over the last 30 years, but I couldn't really put my finger on until an extensive investigative report was done by one of the attorneys in the city of Los Angeles with the Right to Counsel Coalition. I became a part of the steering committee, and we're still fighting to codify this right. But it was actually passed so that every tenant that receives an eviction notice can have the right to have an attorney represent them in court. The struggle is still continued for funding, of course. When the Right to Counsel was formed, it was a collaborative work between 10 different law firms that represented tenants that were served with evictions and 10 community-based organizations that assisted with educating rights. The organizations got together and they formed, which is now Stay Housed LA. There's actually a website, stayhousedla.org. With this unique relationship, it uncovered something that was very disturbing, and something that I had suspected but never could really put it together. But I saw it was actually put together in a very informative and constructive way. Oh, Montano, he did an eviction report. It's actually can be seen. It's called the LLC Landlordism and the Eviction Machine Gentrifying Los Angeles. The information would bring to light that, because of attorney-client privilege and confidentiality, it was discovered that a lot of the individuals that received unlawful detainers, it was found that they had received previous evictions filings on them in past years. The pattern was started to become really, really apparent because there is a system in place where landlords that own multiple buildings and units within a community arbitrarily filed evictions on tenants within buildings every 18 to 24 months. And so with these filings, they would also use the scare tactics and taunt them and harass the tenants. And the owners would also cease making all the repairs. And even if the tenants would leave, the filings would actually continue. And 9 times out of 10, the tenant would result in getting eviction on their record by default, not even with their knowledge. One of the major um, uh, even if major repairs needed to be made within the apartment, like water damage or some other major issue, it would result in a constructive eviction to the tenant. It was cheaper because no matter what went wrong, they would just blame the tenant. Even if there were habitability and maintenance issues, they would get rid of the tenant. They would fix the problem without them being there. It was a zero cost to them for relocation. They would keep the person's deposit and possibly filed a default judgment on them that the tenant would have to pay later. And then all of the renovations that they made and that were done were paid by the tenant. And then, of course, they would rent the apartment to the next person at a higher market rate. Only to note that what we've been finding within our community is most of the apartment units had delayed maintenance for years and sometimes decades. So that's very problematic. What was also discovered is that the people that had been in the units the longest, they were the ones that were they were actually targeted. And even if these rents were rent stabilized, the rents were so low for them that sometimes they would have been there in this community for maybe 10, 15, or 20 years. It was worth for the owner to evict them and to increase to the market rate after they departed. Now, this creates a very systematic machine that destroys the reputation and the credit and the ability to find housing for these individuals. What we also have discovered is that the tactics that were utilized were done in predominantly African American neighborhoods, and some of them had a very high population of Latinx. But the only thing that they would do is just add the threat of ICE that they were already using. This creates a very serious problem, and it adds to the factors that I kind of mentioned earlier. One being eviction, because a constructive eviction is still an eviction on record. The second aspect is, along with the court judgment, that affects the individual's credit rating and their ability to obtain housing in the future. The third, of course, being if any time one of the individuals had spent some time being incarcerated, many leases had clauses where they couldn't return home or even visit their family members, irregardless to if it was a husband or wife or maybe a son or daughter returning to their very same address. And of course, the overall negative views of African Americans in housing, period, and attitudes after years of disinvestment in the rental units by the owners and the neighborhoods by the city and some of the counties. When it comes to housing and incarceration, so much there's no such thing as a person having to have paid their debt to society and then to move on and move forward. The system is put in place that automatically upon release that there's no place for the person to go back home and get on their feet. The family is forced to sometimes relocate if they want to maintain being a whole family unit. And in subsides, what we were finding is that those families are not able to really afford to do that. The situation becomes really heartbreaking when we look at the statistics of African Americans that are incarcerated, but no one really examines, that may have took a deal or was, released without even having a trial and were actually not guilty. And to me, that is like a gateway to homelessness. That in itself is only partially addressed in the social equity program for minor offenses like marijuana, and that's kind of like a different aspect of reparations, that we were dealing with in Los Angeles. But when it comes to housing, we look at the three factors that I mentioned before, and those three factors make you 100% ineligible for affordable housing. We really need to examine how the most of those that are in the most need, that reside in low and very low income, brackets, are subjugated and removed, and they become ineligible for the very housing that was actually designed for them. This aspect also is what causes homelessness. Um, we look at the explosive and the exploitive nature of how systematically everyone with more resources coming from somewhere else can replace and be given priority over longtime community residents within the same neighborhood. And that aspect is just gentrification. We need to also give consideration to housing being the key factor and instability and and a component to a healthy and sustainable life. Everything else actually improves with having a safe and habitable place to stay. When you can live somewhere and not be worried about the stresses of being displaced. All of the determinants of health are tied to a person's individual housing and having a long-term and permanent place to live. Most of these things include income and their social status, basically social support networks, quality health care and hospital, urgent care centers and their treatment, education and literacy, these materials and resources, unemployment and working conditions, benefits and pay equality, social environments where there's enough green space and locations for recreation, exercise, entertainment, and along with cultural relationships, physical environments, basic amenities that are located within the community, and just plain fresh air, personal health practices and coping skills, having a safe and secure place for a person to rest their head at night without the fear or removed, and to be able to provide for one's personal hygiene on a regular basis. Healthy child development with parks and activities for the youth, and also food security. The absence of food deserts and plenty supermarkets and local farmers markets and healthy options, with organic foods. When it comes to reparations, the solution would have to be able to even the playing field. It would have to be, dished out in an equitable manner that's irrevocable and does not expire for African Americans. The solution of monetary or benefit should have a value that's quantitative. This value should not diminish. And if not used all at once, the portion not used should increase by interest. It should have a consideration to the area in which the individual resides, whether it be a relocation or due to economic factors, or a place that a family has migrated to years earlier. There should be no limitation on the housing type or size, features, yard, or even, like I said before, location. Priority should be given to any purchase of a property that had a racial covenant upon its deed. And additional property priority should be given if the property is purchased or owned in a previously red line district. We could start by acknowledging and give a formal apology and have formal teachings and the laws and policies that California has partaken. And first, we can start to heal past wrongs in the state African American housing. And, I have a short list, but it's not limited to, previous histories of burnings and massacres should be fully compensated. Redlining should be given priority. Eminent domain should be prohibited. Racial covenants should be expunged. Flooded towns should be completely compensated. Broken windows, the records of those individuals should be expunged. The California Constitution, Article 34, should be repealed. Gang injunctions should be abolished, and nuisance abatements should be banned. And all of these when it comes to housing for African Americans. The injuries are overlapping when it comes to the housing in Black communities, and the ability to obtain and remain in their homes has been difficult enough. The ultimate goal for African Americans is to obtain, remain, and ultimately be left alone. And I wanted to give you and share with you a quote of one of my good friends. She's Korean, and she always said that because they have always concentrated on keeping the African American down and disenfranchised, she said she's noticed in the last 30 years that, you know, they've actually ignored the Asian population and they were able to thrive. And so I thought that was a very interesting quote, but I just wanted to share that. And I also wanted to tell everybody thank you and for giving me the opportunity, and I appreciate you listening.
Thank you so much, Zarita Jones, for your powerful testimony. So we'll now turn to Damian Goodman. Damian Goodman,
can you hear me now?
Can we hear you okay? Yes, we can hear you fine. You may begin. Thank
Awesome.
you.
Thank you. First, there's a presentation, but as that comes up, you know, I stand here today on the shoulders of my ancestors. My great-great-grandfather, Charles Blodgett, and great-great-granduncle, L.M. Blodgett, son of enslaved Africans, migrated to Los Angeles from the segregated South around 1904. They literally built much of Black Los Angeles. They were builders who built many of the historic structures on Central Avenue, including the first headquarters of Golden State Mutual Life Insurance. They built the first FHA-backed housing for Black people in all of America, the Blodgett Track, much of which was destroyed with the construction of the 105 freeway. In the 1920s, in response to white banks' refusal to provide home loans to Black people, they founded Liberty Savings and Loan Association to provide mortgages and four walls and a roof to Black people seeking a safe place to, at least in a racist society, call their home their own. The bank, which survived the Great Depression, would be acquired through a hostile takeover from a white bank in the 1960s. L.M. Blodgett, who was known as Old Man Blodgett, married Nella Allensworth, the daughter of Colonel Allen Allensworth, and Josephine, who moved down to Los Angeles to be with them in the 1920s after the colonel's untimely death. I know they are looking down on me and us today, and I hope we and I can honor their legacy. But over a century after they arrived in Los Angeles, I find myself needing to do the honorable work of pursuing housing justice for Black people and economic liberation for Black communities under many similar and some dissimilar circumstances. As a 28-year resident and renter in Leimert Park, our Africatown, for the last 15 years, I've led advocacy and policy work that is focused on just communities and the impact of state decisions on the traditionally Black and brown community of South Central Los Angeles, with a hyper focus over the past 5 years on gentrification. If we could go to slide 3, please. Next slide, please. About power. Malcolm X said revolution is based on land. Land is the basis for all independence. Land is the basis of freedom, justice, and equality. And I will offer commissioners, senator, assembly member, every war in human history has been about land and access to land. Next slide, please. And so as we look towards solutions to the crisis of gentrification for Black people and Black communities, at its root, we have to talk about the current and past harm that has been done through actions and policies and transferring power to Black and marginalized communities, recognizing that Black communities have a right to self-determination, recognizing that the government power, which is currently being used in a different manner, can be used to regulate a racist housing system, recognizing that government power and specifically budgets have to be directed and redirected toward building a reparative and restorative economic system where, among other elements, housing is decommodified and Black families, businesses, institutions thrive, grow, and thrive free from the winds of exploitative and a racist capitalist system. Right now, the power rests in capital, with speculators, developers, banks, and regrettably commissioners, senator, assembly member, the state, with its overt acts of passing harmful legislation and its failure to use its state power to regulate the evils of racialized capitalism, the failure to pass protections for vulnerable communities, failure to pass protections for those harmed by the history of American chattel slavery. Next slide, please. I believe I was brought to this illustrious body to be blunt, so allow me to do so. The state's housing policy as it is today is racist. And every state apparatus, including the Attorney General's office, the governor, the courts, and unfortunately the legislature, continues the sad tradition and morally repugnant history of urban renewal, which James Baldwin appropriately titled Negro removal. We are now in an urban renewal 2.0, and it is a deliberate man-made attempt to remake the urban core where Black, Indigenous people of color disproportionately reside into a space for more affluent, whiter gentry and remove hundreds of thousands of marginalized and Black Californians from their homes. Instead of calling gentrification in our racialized housing market a policy failure, that is completely inaccurate. We should call it what it is, which is the successful policy, the successful public policy. Gentrification is the manifestation of the coordinated public and private policy and processes intended to create profit for elite investors of harms that are inflicted on low-income, working-class, and marginalized people who are disproportionately Black. Noted urban geography Neil Smith's seminal work, Gentrification as Global Strategy, dives into this global process of capital going towards an urban remake a lot more. And activists throughout the country, including an amazing brother who's in DC by Aristotle Teresa, he's waging litigation currently that brings to light documentation that shows how local government is engaged in an intentional process through market rate project approval to change Black communities into those for a more and wider and richer creative class. It is the intent to use state power on behalf of capital, operating within an anti-Black American society and world that we see and much recognize, because only by recognizing this public and private sector cohesive and coordinated anti-Black weapon can we begin to answer the question of what can be done to disarm it and what can be done to repair the harm done both past and currently being done. It is how you can see the frequently referenced false solutions for what they are. They actually serve in many cases to exacerbate inequality and are leading to increase resegregation through gentrification by pushing Black people currently in an urban core out to far from suburbs where there is less opportunity, less social infrastructure, and where their social fabric has been lived. We could go to slide 62. And more. 6-2. Keep on. This is actually from our Gentrification 101, or at least this portion, where we dive in for about 8 hours. 62, please. Slide 62.
Give me one moment, please.
No problem. Where we dive into what's taking place on a global scale, the particular American context that puts Black communities at risk, along with getting people to recognize the true actors and solutions. It's actually in its condensed form, 2 4-hour sessions back to back. And I say condensed because it comes from the work of Crenshaw Subway Coalition, Uplift Inglewood, Hyde Park Organizational Partnership for Empowerment, and bringing together and trying to get greater understanding of what's taking place in our community. There was originally a six-week consecutive popular education project where we dove into our own experiences and sought to understand what we were seeing. They're going to do the same here today, hopefully by getting to a point once we get to slide 62, where we see that gentrification is the result of global decisions in capital. 62.
Okay, I apologize. We reordered them for you, and it doesn't seem to be.
Okay, keep going. Oh no, back up. Wow, they're all reordered. No. Okay,
Closer.
yes. There we go. Back a little bit more.
There we go.
Perfect. So who are
Apologize.
the actors? Who are the perpetrators? And let us understand why this is a little bit different today than what it was in the beginning. And some of the causes. One of the major driving forces in current gentrification is financial industry deregulation. Banks now are both the source of capital investment, construction bonds, and they hold the mortgage. They're willing to increase the credit of some, particularly speculators, which we'll get into, and those who are more affluent, and are continuing the process of discriminating against, as I think other speakers have referenced, Black people who have the same income and credit scores as white people. With foreign borders falling, we're now allowing into the country a record amount of foreign investment and speculation, where people are looking to park money into what we call frequently vertical safe deposit box, because they are speculating on a return in value in the changing of urban communities. Next slide, please. And so some of the big changes that we're beginning to see on the ground here is that many of the mom and pop landlords that operated those small single family or small multifamily properties are now being owned by Wall Street investors. Many of the corporate actors, or many of the actors who are buying these homes, are not even known to the tenants because they're operating in LLCs with invisible investors. It's been quite well known that private equity firm, among them the largest in the world, BlackRock, are now buying single family homes, and we see what that disruption has done to the market. Less talked about is that they're using public pension funds as part of those dollars to engage in that unsettling of a single family home market. We go into this a lot more, but the investment primarily, we go into this a lot more within our advocacy work, CrenshawSubwayCoalition.org/gentrification101, but they're focusing on the low income market, better known as the starter home market, for a specific reason. We'll get to that. We're seeing that Airbnb is taking housing off of the market that otherwise would be occupied by renters. We're seeing the flippers, and we are seeing, most importantly and most vividly in the work we're doing, the consequences of upzoning and speculative real estate development. Next slide, please. Next slide. And so with this chart, which comes from the Anti-Eviction Mapping Project, we're seeking to kind of get people to understand how the concentration of corporate ownership is in low-income communities. BlackRock is a $8 trillion operation. They could buy homes anywhere on the planet. But they and entities like them focus in, and this is the Southern California region, in disproportionately Black and brown communities for a specific reason. You'll see there are no dots, very few dots on this map for Santa Monica or Beverly Hills or West Hollywood. Lots in Compton, lots in Inglewood, the Crenshaw community, Glenwood, places where Black people and people of color reside. Next slide, please. In addition to that, you're seeing with crowdfunding that was adopted and allowed through the Jobs Act that was passed by our President Obama, that many smaller investors, not just large global investors, but many smaller investors are now buying some of these single family homes, some of these multifamily properties that otherwise would go to mom and pop landlords who are less likely to engage in nefarious activities to push out the tenants. Here you see, much like it's a stock market, people who are investors and can do so literally from their pajamas in Singapore, can buy into and invest into an operation that seeks to buy, and these are rent control properties for the multifamilies, because they're in Los Angeles, they were built well before 1978. Buy into rent control properties and take ownership on the belief that they'll get a greater return, and a much greater return than would be allowed under the current rent stabilization ordinance. Next slide, please. Next slide. And we're seeing the consequences before previous slide. We're seeing the consequences of, previous slide, please. We're seeing the consequences of rampant rezoning. Upzoning, rezoning, which is well known as problematic in the East Coast and has unfortunately become the conversation and topic of discussion here in California, is creating value in land that the home itself does not have. It is real simple. if you have a home and you can build only one unit on the home, it is sold as a single family home. If that plot of land can then be built for 10 units, then the value of that home increases because it's not based on the value of the property on it, which is already built. It's based on the value of what you can build with the property and change it into. Here's a listing for $1 million home in the mid-city community that used to be actually very racially diverse and is now becoming less so, where you see the realtor specifically saying this home for $1 million is not priced for a family. It is priced for what is known as a transit-oriented communities project, a redevelopment, and he's seeking investors. We're finding this out as on behalf of our community. We're engaging in small site acquisitions through the Liberty Community Land Trust, where we see regularly references to upzoning, regularly references to transit-oriented communities, SB 9, ADUs, and seeing the value of the homes and the values of the property predicated on that change, not predicated on the value or the rents of the property as they currently exist. Next slide, please. And here you're seeing that in this broad context, while we as a community-based organization would need to go and get traditional lending, those who are engaged in this flipping, who again are targeting and focusing on Black communities, are often doing it with no capital. There are loads of hard money lenders and others that allow you to and provide lots of training on how to buy that single family home or how to buy that multifamily and flip it literally without any of your own dollars. Next slide, please. So why are they focusing on communities like Crenshaw and Compton and other Black, brown, and communities of marginalized people? Again, urban geographer Neil Smith identifies this and explains this through the rent gap theory. The difference between the actual rent, what's actually being paid right now, and the potential rent. These communities, through transit infrastructure investment, the increase of the creative class and directly adjacent Culver City's Hayden track, increase in the creative opportunity in downtown Los Angeles, are focusing on areas where there has traditionally been undervalued real estate. And now, and I'm sure if Pete was here, he would have talked about the criminalization and the dang injunctions that have been used have been, in some respects, made more quote unquote safe, are safe not just for people to reside, but safe for capital to return to. It's only by removing the existing residents, who again are disproportionately low income, Black, brown, that you can realize that new gain. That gap in communities where you're in low income communities is significantly greater than they ever would be in a Beverly Hills or a West Hollywood. Next slide, please. And so now we're going to talk a little bit about a specific project and the consequences of this upzoning decision. This is District Square. District Square is located at the intersection, a project that is proposed at the intersection of Obama and Crenshaw, where a former Ralph's grocery store used to be at, but was torn down by the developer. And it was a proposed multi-unit property, 577 units, 100% market rate in the heart of Black LA in the Leimert Park community. The city of Los Angeles has said that to afford a market rate home in South Los Angeles, or market rate home in the city of Los Angeles, the family needs to make at least $125,000 per year or more. The median household income for families in the area that surrounds this project is $45,000. Next slide, please. And so after we got wind of this project, the developer who literally was working on it was arrested for bribery. Not for this specific bribery, but for bribing a public official in another engagement. And just to be clear, the person who he bribed has already admitted their guilt. He's just awaiting going to court. So here we have a project that's intended to gentrify our community, a project that has a developer who's literally on trial for bribing a public official and is likely on his way to prison. Next slide, please. And that came at a time where a state law was used to ram the project through. Within 15 days' notice, this total rework of this massive project that was going to unleash an untold amount of indirect displacement and was completely unaffordable to a Black community was to be approved without even a public hearing. Our organization, the Crenshaw Subway Coalition, filed an appeal, and we succeeded in doing something that almost never happens. We were able to convince the Area Planning Commission to reject the project, we weren't only able to convince the area planning division to reject the project, we were able to get them to do it on the grounds that it would increase displacement, gentrification, and houselessness. We even got the council member to come out and list some quite powerful words in saying that if the current residents of the neighborhood cannot afford the project, it should not be built. Next slide, please. And so, to our dismay, a YIMBY group out of the Bay Area, known as CARLA, for the California Renters Legal Advocacy and Education Fund, which had pushed the very law that made this quick, streamlined approval of this massive market rate project in a low-income community, actually spoke out in support of it. They referenced the Housing Accountability Act, which again has been referenced many times in the public, and people frequently think about typical, more affluent white NIMBYs, ignoring